Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal. You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. In this special episode, we'll be discussing the case of Planned Parenthood versus Medina. It's a case we've covered earlier, but we want to go into a little bit of a deeper dive here. So the case is currently awaiting decision by the U.S. Supreme Court. Oral arguments were held about a month ago. And joining us for this discussion is Kyle Nazareth, an attorney and a current fellow with Napa Legal's Good Counselor Project. So, Kyle, thanks for joining us, first of all. Before we begin, why don't you tell us a bit about, how do you find yourself on this podcast discussing this case in particular? What led you here?
Hey Frank, I'm really appreciate you guys having me. I've been watching the podcast for a while now since I became a fellow, so it's definitely an honor. What kind of brought me into it is, the great kind of development you get as a good counselor project fellow, and you really get to write about different topics, to talk about different topics of interest in the kind of nonprofit, religious liberty sphere. I've always been really interested in that, and had my eye on this oral argument in the Medina case that really caught my interest, and kind of the issues involved in the pro-life kind of advocacy really struck a chord with the mission and vocation of what we do here at the GCP Fellowship. So I took an interest in it and wanted to come on and talk about the article I wrote as well.
Great. Yeah, it's a great case to pick and run with, right? Because you have the obvious pro-life issues for a lot of folks in the religious liberty sphere, but there's also for us kind of like legal and policy nerds, they're really interesting cases of federalism, right? What's the proper domain of the states versus the federal government? There's a lot here. We've covered it a little bit previously, but let's recap. So, if you wouldn't mind briefly, let's just start with the facts. Tell us a little bit about the case, what's going on, what led to it, why, and also, why was this issue sufficiently important to justify the Supreme Court weighing in?
Yeah, definitely. So I think what's really central to this case is the discussion about Medicaid. And just for people who are unaware, that's the federal health care program for low income Americans, which Congress enacted under the spending clause. And how it kind of works is that states can manage their own Medicaid programs and they get money from the federal government, but the federal government gives them that money with certain conditions attached, um, in order for the states to receive that money. And one of those conditions is called the Any Qualified Provider provision in the Medicaid Act. It basically says a Medicaid recipient may obtain medical services from any provider who is qualified to perform them. So that's the kind of important legislative and background information that's needed before kind of jumping to the facts. So in 2018, the South Carolina governor at the time, Henry McMaster, he signed an executive order declaring Planned Parenthood was unqualified for the state's Medicare or Medicaid program. And he pointed to a state law that bans public funding from supporting abortion services. And I think from here, I'll probably loop back around to exactly whether this issue is sufficient to justify SCOTUS kind of weighing in. I definitely think it is. But I think really what Governor McMaster's kind of executive order touches on the most is kind of the question about how directly relevant the issue of abortion is. And I know we discussed that question a little bit before we start recording. So
Yeah, so this is fascinating. And now, oh, there's a lot going on here. So, if I understand correctly, this case, this case that went up to the court, is not specifically about Medicaid dollars for abortion. And you can correct me if I'm wrong, but if I think Medicaid dollars, as it stands, can't be spent directly on abortions. But what makes this case different and worth weighing in on, right, is that it's not that South Carolina said money can't go toward an abortion at Planned Parenthood for Medicaid, because that's already part of the Medicaid statute, if I understand it correctly. But rather that the governor of South Carolina said Planned Parenthood is unqualified to be a service provider for Medicaid dollars generally, like even if they're not providing an abortion. Is that right?
yeah, so I think I'll take that question in two parts. The first is kind of, well, is this case directly about abortion? And in terms of the legal question, yes and no. The legal question purely isn't directly about abortion or like abortion rights or access to abortion directly. It's kind of implicitly about abortion though, and that kind of political issue is lurking in the background and really motivating the parties here and even the justices, I think. And you're right, like Medicare or Medicaid funds can be spent on non-abortion care, some of which Planned Parenthood does, right? They do some reproductive care, screenings for cancer, measuring high blood pressure, things of that like, which they can receive federal dollars for. But the argument that the governor makes in that executive order is really about how money is fungible, right? So Medicaid funds that go to abortion clinics, even though the money might be used for non-abortion care, is still effectively subsidizing abortion because it's not like in the background in their bank accounts they have specific bank accounts for non-abortion care, abortion care. It's all in one pot. So the money's fungible, and you know, providing public dollars even for non-abortion care probably does go to uh, abortion care in some sense.
Yeah,
So,
that's a good point before you go on to your
mhm,
second point. I think it's worth clarifying. This is not the only place where this kind of argument is going on right now, right? We've seen, and this is outside the sphere of religious liberty directly, I suppose, but like on the university level, right? Universities that are taking public funds, and there's been some fighting because a lot of these universities have had huge administrative diversity, equity, and inclusion initiatives, right? But they'll say, well,
mhm,
yeah, we're taking millions and millions of dollars in federal funding, but it's for our science program, it's for our medicine, our research program. And to your point, it's like, well, okay, but if we're giving you tons of money and you're putting it in one place and it's freeing up other money to do the DEI thing. So you're right. If you're funding an organization, you're funding the organization and you're funding everything it does. That's, I think, a strong argument, even if in this case, not technically a dollar for abortion, it's still a dollar for an abortion provider.
yeah, and I think you saw the same thing in the Burwell versus Hobby Lobby case too, even in the religious liberty sphere, where we're kind of talking about the Obamacare kind of regulation that required employers their health insurance for employees to provide for certain kinds of contraception, right? And the argument was, well, Hobby Lobby was a couple degrees removed from it. They didn't weren't directly providing like the contraceptives themselves. It was employees going to pick that healthcare plan and the healthcare insurance, paying the money for those things. But it's the same idea of fungible money.
Yeah, that's an important point. Now, did you have another point on this, on the abortion question?
Not on the abortion question. It was more the kind of second thing about what this case is about, whether it's about the state of South Carolina being able to say who's qualified or unqualified under the any qualified provider provision, and kind of it being about not exactly about state power. In more of a general sense, it is kind of about state power, right? It's kind of, can South Carolina disallow Planned Parenthood from the Medicaid program? Um, but I think the reason behind that general question, there's a more specific question about Section 1983. And again, it's a little like you need a little bit of background to kind of understand some of these
Yeah,
things.
go for
And yeah, so usually if someone wants to file a federal lawsuit enforcing provision of the Medicaid law, they can't sue under the Medicaid law itself. They have to file a Section 1983 claim um, that federal law allows individuals to or state official to sorry individuals to sue state officials um, for a violation of a federal right or a constitutional right. And so that's kind of really what this case is about. There is a state law issue lurking in the background, similar to the abortion issue, but it's really about whether there's a federal right to sue in like contained within the text of the any qualified provider provision. Um, because that's what the respondents would allege South Carolina wrongfully did by disallowing Planned Parenthood from the Medicaid program.
right. Now, this is going off script. So if you don't have a quick answer on him, but now I'm thinking through this case, and you're right because this on one hand, this is not just like a general federalism question in the state saying, well, we have the right to do whatever we want with qualified service provider, right? But because if you change the facts around so it wasn't an abortion provider, I don't think you'd get here, right? Like if Governor McMaster had just said like, Dr. Smith and Dr. Johnson are not qualified service providers because I don't like those guys, right? Like then we have a very different case, right? Like
Yeah.
that's not what anybody's arguing for the power to do here, correct?
hmm Exactly. Yeah. It's really about the enforcement of whether a right is contained in that Medicaid Act. Act and under the any qualified provider provision. So it's not exactly about the state being able to say who's qualified or unqualified. It's really about the ability to sue the state if there's an alleged violation of that provision. And I think that kind of loops back around to your first question about whether this issue is sufficiently kind of important to justify SCOTUS weighing in. Because again, how a lot of these federal spending clause statutes work, they very rarely say in the text of the statute that it's conferring a right under Section 1983, right? They're not going to say, for the most part, and this is a right. It's very rare to have that language. And therefore, the courts have to look to the text and structure and to try to ascertain whether a federal right is being created in the language of that statute to have a Section 1983 claim. And then, the juicy question for the Supreme Court is, well, how do we do this? And just to go through the procedural history a little bit
Yeah.
quickly. So the Fourth Circuit, this case bounced around 2 or 3 times. There was 3 cert petitions filed, but in summary, really, the Fourth Circuit eventually agreed with Planned Parenthood. The Medicaid Act creates individual rights. They can be enforced under Section 1983, and the Fourth Circuit relied on 3 main cases: Wilder versus Virginia Hospital Association, Blessing versus Freestone, and the most recent 2023 case is Health and Hospital Corporation of Marion versus Talavesky. And really, they have different analyses. The most recent case, the Talavesky case, the analysis is about whether the provision in question is phrased in terms of the persons benefited and contains rights creating, individual centric language with an unmistakable focus on the benefited class. So that rights creating language test is really important from the Talavesky case, and it kind of differs from the former 2 cases. Um, I think from my reading of that case that it's really trying to reconcile the former 2 cases without overruling them. It basically says that the most recent one, Talavesky, that there has to be a high bar for creating rights language still in order to allow a lawsuit under 1983. And so finally, we get to why the court actually granted cert finally on this case. And I think they agreed to hear oral argument because in the Fourth Circuit's decision, there was a concurrence by Judge Richardson. And he wrote that, okay, reading these 3 cases together, they don't really make sense or present a really clear rule. And asked the court to clarify about when a spending clause or a piece of legislation enacted by the spending clause allows for a plaintiff to bring a Section 1983 claim. Like, what is the specific language to create a right of private enforcement?
Yeah, this is fascinating. I have a couple things I want to follow up on there. And my it's a shame that my colleague Mary Margaret is not on this one, my usual co-host, because she's a huge 1983 deep diver. But I have a couple of thoughts here. So for one, just to clarify, so in this Planned Parenthood versus Medina case, what exactly is the right? Like, can you summarize the right that they're claiming is being violated that justifies the 1983 action? It's a right to what?
So it would be their interpretation of the any qualified provider provision is basically that um, the name is slipping me of the individual who's actually denied the Medicare beneficiary who was able to actually um, try to pick Planned Parenthood as the provider, but essentially that she has a right to have Planned Parenthood as a provider. This is an individual right under that reading of the provision, and also that the Medicaid Act creates a right of enforcement that under 1983 is she can sue under. So
Right.
that's really the main thing is the choice to have Planned Parenthood as a medical provider, pretty much.
This is fascinating on 2 levels. These are 2 very separate thoughts I have here, and you don't have to weigh in if you don't want to, because they're just kind of coming up as I think through this case further. But for one, I would love to see a more fundamental level analysis from somebody who knows 1983 better than I do, because again, without going into the precedent on it, just the plain reading of the statute, I think it's questionable whether you can sue under a non-constitutional right at all, because of the way it's
Hmm.
worded, right? You can, if you're deprived of any rights, privileges, or immunities secured by the Constitution and laws, that's what
Hmm.
creates the right of action. And I would think if it's if a right under 1983 can come from either the Constitution or a non-constitutional body of law like a statute, I would think that Constitution or laws of the United States would be a cleaner way to say that. So I don't know. I think it's kind of ambiguous in the statute itself, whether there's a statutory right that can justify 1983. And again, I'm not going off the precedents. It's just the plain reading of the paragraph long statute there. Um, if you have any thoughts on that, feel free to weigh in. But I think that itself should not be a settled question at this point.
Yeah, definitely. And I think that touches a little bit on what Justice Thomas said in a dissent, and Justice Alito kind of mentioned in the oral argument is about, well, okay, let's take these spending clause enacted statutes. They don't create rights, they only create conditions on the states to receive federal funding,
Yeah.
right? So that doesn't really make a lot of sense. But I think I've even kind of seen this in a different sphere as well, where you start creating more and more rights from things like benefits, or uh, maybe privilege isn't the right term, but I think I remember when I was in law school, there's a admin law case called Goldberg versus Kelly, where the court decided that entitlements like welfare payments are a new form of property, and they do away with the kind of traditional distinction between rights and privileges. So you see that kind of slowly decaying more and more as we got into the point now, where hopefully we come up with a bright line rule, like Justice Kavanaugh is kind of mentioning in the oral argument. But it seems as if there's no bright line rule, and the bar is so low to take the any qualified provider provision, then I mean almost any spending clause, or yeah, spending clause enacted legislation could create a new right, right?
Yeah. And I don't think, I think that's a serious problem in warping what Section 1983 was created to do, which was to give a cause of action to enforcement of constitutional rights, not anything that you can construe as a right within like a spending clause statute. But
Hmm.
that's fascinating. I'm curious to see how the court handles that particular issue. But then I have another one that maybe I'm missing something, maybe this is really obvious, but so even if you grant that the Medicaid legislation creates a right, right, that justifies a
Hmm.
1983 action. And it's like you said, a right to any qualified service provider, right? Medical treatment from any provider, including Planned Parenthood. There's still a problem because it's any qualified service provider. So there's still an obvious question of who decides who a qualified provider is, right? Even if there's a right to any qualified provider, there still has to be, and I would say it's the state that has to decide what makes for a qualified medical provider under Medicaid. So I think we're still in the same place. Even if you grant them that they have, standing under 1983, there's still a problem that it's not an unlimited right to any service provider that the patient deems to be qualified, right? So is
Hmm.
that touched on at all in this case?
So I think one of my headphones just died. Can you still hear me, Frank?
Yeah, I can hear you.
Okay, great, perfect. Um, Sorry, would you mind repeating the question now?
Yeah, even if you grant that the plaintiff in this case has a legitimate 1983 claim to a right, it's still the right to a qualified service provider, and it's still, I would think, up to the state to decide who's qualified or not. So even if there's a
Hmm.
right, doesn't the state still
Hmm.
have the ability to say, well, essentially Planned Parenthood is an abortion service, and that's 90 whatever percent of their money, and that's not a qualified service provider. So if you have a right to qualified service providers, fine, you have a cause of action, but Planned Parenthood is not one of them, so it still falls outside the right. Is there something there?
Yeah, definitely. And I think that's the biggest kind of issue without a clear statement of creating a right. It shouldn't be interpreted as creating a right then. It should be created as, well, Congress intended to leave this discretion to the states then, where there's no clear language of right creation, right? Pretty much. And there seems to be even deeper issues of federalism by creating rights without clear statements. Um, there's a I remember a case from law school, it's called South Dakota versus Dole, about attaching strings to money, to federal funds, pretty much. And one of the elements of when that's acceptable is that the conditions have to be unambiguous, right? And that's the kind of big problem with this, is that there's clearly not unambiguous language creating a right. It would have to be an implied right of enforcement. And an even deeper issue with that is that through the spending clause, something like the Medicaid Act is akin to creating a contract between the federal government and the states. Um, and just think about it like any other contract, right? When you kind of sign the papers, get it all done, and then later the state learns of the new term that was implied that they never knew about, which opens them up to huge liability if they get sued, right? I mean, there's clearly not like a meeting of minds. Then what's the reasonable expectation of the state if all of a sudden these new rights are being discovered in the language of the Any Qualified Provider Act? So that would seem like a huge federalism problem to me.
Yeah, I think that's right. Even if we settle several of the questions that we've discussed on the side of Planned Parenthood and the plaintiff who wanted Planned Parenthood services, I think you're still left with this big question of, does the language in the federal statute justify, limiting, in this case, South Carolina's ability to decide who's a qualified provider? And I would say no. I mean, even if you let's say the federal government can tie the money up in very specific ways, right? Let's say there is a 1983 enforceable right here. There's still this problem of, if federal government wanted to tie this money down to a place where Planned Parenthoods anywhere they exist can get these Medicaid dollars for non-abortion services, they could have done that, right? You can specify in
Hmm.
the statute and say, for purposes of Medicaid dollars, a qualified medical provider is, you know, a clinic that exists within the borders of the state and that provides any of the following services: A, B, C, D, E, F, G, H, right? And if they did that, then we'd have a different fight, but we wouldn't
Hmm.
have this fight where it's like, well, exactly what you said. It's not clear. And if anything, I would say that in this ambiguity, I think the much stronger argument is it's up to the state to decide what's a qualified provider.
Yeah, yeah, I definitely agree with that, and especially where I mean, Justice Alito, I think, pointed this out in the oral argument as well, where the Medicaid money is essentially mandatory, right? Like we saw this in the Obamacare case, the NFIB versus Sibelius, where I mean, all of these states take the Medicare money. It makes up a huge portion of their budgets, and to force them to choose between, okay, either I voluntarily don't take the federal money, which makes up a huge portion of my budget, or I have to open myself up to an ambiguous implied cause of action that would incur huge liability upon the state and cause a wave of flooding of cases. I mean, that's like pointing a gun to the state's head, pretty much, right? It's a huge classic federalism story of whether an act of Congress invades the sovereignty of the state that's reserved by the 10th Amendment. I think that could even constitute like an unconstitutional condition.
Yeah, that's an interesting thread. Um, Practically, are you aware, are there other states besides South Carolina who have done something similar, whether it's Planned Parenthood or other similar, like abortion providers, who have been excluded from this qualified provider statute? Are you aware of any?
So I'm not off the top of my head, but I do have to imagine that since the Dobbs decision and the Supreme Court kind of sending it back to the states, um, I would have to imagine this is happening more and more now, where the states are kind of getting to decide what they want to fund with the money in their Medicaid programs. So I think it'll probably happen more and more now that you see states that are more pro-life trying to implement pro-life policies through choosing who they want to have in their Medicaid program and what providers they really want to include. So I'm not exactly sure of whether this is a trend catching on, but I kind of have to assume it is.
Yeah, that's a good point. I would say even if it isn't, I think if the way, depending on the way this case is decided, it will be, right? Because
Hmm.
you're right. I'm glad you mentioned Dobbs, because post Dobbs, most of the pro-life action has been happening at the state level. And then if this case comes down, this becomes a tool, right, in the arsenal of pro-life states to say, well, this is one way that we can restrict abortions lawfully in our states by not letting
Hmm.
Medicaid dollars go to abortion providers. So I think you're right. Whether or not this is already a trend, my guess is it will be if this opinion is written the way that at least I would hope that will be.
Yeah, I do seem to think that maybe it could go less in favor of the South Carolina. Um, it seemed like Justice Barrett and Justice Roberts, it seemed like they were more into the notion that Televesky lays out like a very clear rule that there's not a lot of confusion about. And I think during the oral argument, even Justice Barrett asked counsel for respondents for Planned Parenthood whether the court could just say in its opinion that the lower court should follow Televisky.
Mhm.
It's clear, right? They could just basically affirm, and the respondents counsel didn't object to that. So I wouldn't say that's necessarily the best sign if they are asking questions about at least two of the more maybe moderate leaning or institutionalist kind of justices are more asking questions about a simple kind of affirmance like that.
Yeah. Yeah, that's always, especially in a case like this, right? When
Hmm.
cases get really into the weeds of procedure, and technical rules, then it's not as clean cut as a lot of the maybe like policy wonks who want a hot button answer to a hot button question are likely to want, right? This could come down to a technical question that might not get us the precedent that those of us in the pro-life world are looking for. Um,
Yeah, yeah. Which is slightly disappointing because we kind of saw this last year in the FDA versus AMH case, where the case kind of threw out the availability of, I think it was mifepristone, according to those FDA regulations, kind of threw out that case on standing. So it's always a little heartbreaking to see when an issue kind of close to the pro-life movement gets thrown out on these somewhat hyper technical issues. But it's a the name of the game, I guess.
yeah. I have a lot of opinions on that that go beyond the scope of this particular podcast discussion. Um, so I guess before we wrap up, do you have any parting thoughts on? I know you kind of mentioned oral argument and how you obviously we never predict outcomes based on oral argument. You never know what a justice is doing, right? They could be asking
Mhm.
questions that are not indicative of how they're going to rule. But any other thoughts on the oral arguments or how you think this is likely to go?
Um, no, not a ton of thoughts exactly on which way I think it'll lean. Um, I think more, I guess, what I could comment on is the wide sweeping kind of ramifications
Yeah,
of this case being decided, because it would affect two things, right? It would affect kind of both the pro-life issue of whether states can choose the medical providers that they want to fund through Medicaid. Effectively, can pro-life states defund Planned Parenthood? And the second issue of the more federalism issue we talked about in state sovereignty, are states free to accept federal funding while still enacting policies that align with their values? Right. So I think not a ton of predictions, but very interested to see the result and the kind of ripple effect that it'll have. This is a really interesting case because it deals with a lot of issues, and it's almost like a Russian nesting doll. Like you can get deeper and deeper and more specific from a big kind of 10th Amendment versus Article 1 kind of debate, all the way down to textual interpretation of the any qualified provider provision. So it's a fun one. Definitely going to look forward to seeing that this summer.
and one more point. So you had mentioned earlier that Medicaid is essentially mandatory, right? Like states can't really opt out of taking Medicaid dollars and providing Medicaid to qualifying residents. Is that right?
So, I mean, they always can, but like what we saw in the NFIB versus Sibelius case is that it's pretty unreasonable to ask them to do so, right? When it makes up a huge, gigantic amount of their budgets, when every state is taking it, right? I think Chief Justice Roberts says that it's like putting a gun up to the state's head to
Yeah.
essentially, that might be hyperbolic language. I might have thrown that in, but it's essentially like putting a gun up the state's head and making them decide against throwing away a huge amount of their budget or to comply with this unconstitutional condition. And that's unacceptable.
Yeah. No, that's a good point. I think it does, even if it's not technically mandatory, right? Medicaid dollars,
Mhm.
it's such a huge chunk of the budget that basically those who need healthcare and are below those poverty thresholds, like the most states can't fund that themselves for the most part. It would be like a total overhaul of the budget. So it does make this a little bit different than a lot of other strings attached federal funding questions, right? Because you have like if there are strings attached to like federal dollars for education, right? Institutes of higher
Mhm.
learning do have an option right? Like actually attract people and use your tuition dollars responsibly, and you can fund a school off of tuition, at
Hmm.
least theoretically. But this is different. Like I don't think you can really do something like um, a healthcare program for underprivileged people without those federal dollars, at least the way a budget's structured right now. So you're right. It's if it's not a literally mandatory program, you still kind of have a gun to your head to a certain point.
Exactly. Yeah. And I will say, like, I'm definitely not the most researched or well versed on this topic. So there are great articles on the Federalist Society website by Jenny Bradley Lichter that I like, reference. And I think who's he? The Solicitor General of the Solicitor General of Iowa,
Mhm.
Eric Wesson. He does
Yeah.
a great video on the Federal Society website, and yeah, definitely worth looking into more than the information I could provide.
Well, if anybody wants to read you had wrote a great little write up recently on this case. So where is that published if people want to check it out?
It's the American Life League. They're a Catholic pro-life organization. So I wrote kind of just a quick update on what was happening with the oral argument in that case for a kind of general audience. But if you guys want to read that, it's in the Wednesday Stop report from 2 weeks ago, and yeah, published in the American Life League. They're doing great work over there.
Great. Well, thank you for being with us, and thank you for coming and talking about this case in particular. It's such an interesting one, and I'm glad you took the time. So thank you, Kyle.
Oh, definitely, Frank. It's been an honor to be on here. I see you and Mary Margaret here all the time, so it's very cool to be on the podcast talking to you guys.
Oh, we're happy to have you. All right. So, with that, thank you for everyone listening for joining us for this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, as always, we'd appreciate it if you like this podcast and subscribe to our channel on YouTube, Spotify, or wherever you happen to be listening from. So, we hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty and the work of faith based nonprofit organizations. Thank you.